We need to talk about the rule of law. A podcast by Verfassungsblog and Deutscher Anwaltsverein. We need to talk about judicial nominations. You don't have to cross the Atlantic and look at the US Supreme Court and the battle about Trump's nominee Amy Coney Barrett to see what is at stake. The judiciary may be as independent as can be, but who gets to be a part of it? Who gets promoted to which court? And who enters the highest ranks within the judiciary? That decision has to be taken by someone, and a lot depends on who that someone is. Controlling judicial nominations is one of the key elements in all authoritarian takeover strategies, which have been implemented in recent years in Poland and Hungary and elsewhere. And this is what I will discuss with our three distinguished guests today. I will talk to Joanna Hetnarowicz-Sikora, a judge at the District Court of Słupsk in northern Poland, and a member of the board of the Independent Judges Association's Justitia. I will talk to Christiane Schmalz, a judge at the highest German civil and criminal court, the Bundesgerichtshof. And I will talk to Filippo Donati, who is a professor of constitutional law at the University of Florence, a lay member of the Concilio Superiore della Magistratura of Italy, and since June of this year, the president of the European Network of Councils of the Judiciary. My name is Max Steinmeiß. I am the editor of Verfassungsblog, and you're listening to our new podcast, We Need to Talk About the Rule of Law, produced together with the German Bar Association Deutscher Anwaltsverein. Now, Judge Hetnarowicz, let's start, for obvious reasons, with Poland. In a nutshell, what has happened with respect to judicial nominations? What has been the state before and what's the state now?
Well, in a really nutshell, I would like to say that for now, we've got over 700 vacancies, open seats for judicial posts in Poland. Judges in Poland, in many places, the judges who disagree with the new construction of nomination of judges boycott official calls for nominations for free posts. They just don't participate in the proceedings. The other group of judges participate in the nomination process just to challenge the decision taken by the National Council for Judiciary in this matter. And in these decisions, judges question the legality of the nomination process and the legality of the new construction of the National Council of Judiciary itself. Those judges who decide to take free posts are pretty often linked to new presidents of courts. They've got also links to the Ministry of Justice, and they give guarantees that they will be loyal and subordinate. Well, that is the situation for now. As you see, the changes in composition and functioning the nomination process in Poland impacts a lot a situation of common courts in every region in Poland. We've got less and less judges and more work. Plus, we have to deal with the situation when among judges, there are judges whose status is questionable because they just took their posts in this new nomination process involving the new National Council for Judiciary.
This new nomination process you mentioned, this new National Council of the Judiciary, what is that about? What is new about it?
Well, first, let me explain the general rule according to which judges are elected in Poland. The mechanism is very simple. The President of Poland appoints judges of every level of judiciary for an indefinite period. This is done upon a motion of the National Council of the Judiciary. Court judges in Poland are nominated by the National Council of the Judiciary and are appointed for life by the President of Poland. This rule applies to judges of common courts of every level of Polish judiciary. In this process, the essential task is the National Council of the Judiciary. As we probably all know, the National Council of the Judiciary is to protect the independence of the judiciary in general. This is its role established by the Constitution of Poland to assure that there is this rule is guaranteed. The members of the National Council of the Judiciary cannot be chosen only by the executive and legislative powers. And it is also assigned in Polish Constitution. Meanwhile, in December 2017, the Parliament adopted a number of important legislative changes related to the National Council of the Judiciary. And this way, the law changed totally, and the checks and balance rule was broken when it comes to the composition of the National Council for the Judiciary. The most controversial were the new rules on the composition of the NCJ, which forced the premature termination of the fourth-year term of office of the judges' members and politicized the election of new members of the new council. Now, 15 members of the National Council of the Judiciary, who are supposed to be judges, and they are nominated by the members of the Polish Parliament. Plus, Polish Parliament also has a right to assign three other members of the National Council of the Judiciary ex officio. So, in this way, most of the members of the National Council of the Judiciary is now recruited by the Parliament, and the Parliament is executive powers, legislative powers. So this radical legislative reform enacted at the end of the 2017 brought serious consequences. The changes appear to have negative effect and prevent the proper performance of the rule of law, of the role entrusted to the Council of the Judiciary in Poland. And moreover, the nomination process has changed. They changed the way the National Council for the Judiciary nominates judges and leads the procedure of nominating. The new appointment mechanism introduces a domination of political powers, as I said, but also is not transparent. And the new National Council for Judiciary has failed, in fact, to implement appropriate standards in the recruitment procedure for judicial posts. The substantive assessment is actually minimized, and the selection is neither fair nor reliable. The National Judicial Council is not obliged to take an opinion of the judicial environment into consideration while nominating the candidates for judicial posts. And the following changes of the new law on common courts practically eliminated any impact of the community of judges on this nomination process. Now the opinion of the General Assembly of Judges of regional courts is no longer needed in the process of nomination of new judges. The only body which is competent to give its opinion about new candidates is a college of a regional court. And the interesting thing is that colleges are now composed mostly of presidents of lower courts of the region. And another interesting thing is that the presidents of most of the common courts in Poland were dismissed from their office by the Minister of Justice in the early 2018, and new, loyal, and subordinated presidents were appointed by the Minister of Justice. This means that the procedure applied in this nomination process lacks the declared transparency at all. And it is totally impacted by the legislative and by the executive.
Right.
And this questions a lot of status of new appointed judges.
I see. Judge Schmalz, defenders of the Polish government like to point to Germany and say, look, the German system is way worse than what we do. It's political control of judicial nominations all over the place. Is that true?
Well, actually, when I listened to my colleague from Poland, I took some notes and I thought, well, it's basically, well, a lot of points are actually also true for Germany. So we have rather no transparency. We have a nomination proceeding which is dominated by politics, and then we have on the federal level. I'm only talking about the federal level because we have 16 different systems in the states, and on the federal level we have a committee composed of basically all politicians to elect the judges. And we have very little input from the judiciary itself on the candidates. So what we have to look at first, perhaps, is that we have this system is provided for in our basic law in Article 95 of the basic law that deals with the federal courts. It says in its second paragraph, it says the judges of those courts shall be chosen jointly by the competent federal minister and a committee for the selection of judges consisting of the competent land ministers, state ministers, and an equal number of members elected by the Bundestag, by the parliament. But we do also have Article 33 in the basic law, which deals with equal citizenship and the public service, and which in its second paragraph provides that every German shall be equally eligible for any public office according to his aptitude, qualifications, and professional achievements. This provision, of course, corresponds to a recommendation of the Committee of Ministers of the Council of Europe, according to which the selection of judges should be based on merit, having regard to qualifications, integrity, ability, and efficiency. But when you look at these two provisions, you can already see that the selection of federal judges in Germany is a combination of a selection on the basis of merit, but with an element of political election. And when you look at the details, one of the problems is that only the federal minister and the members of the committee for the selection or election of judges can nominate candidates for the election. So you can't apply for the posts. You don't even know usually how many posts are open. And then the committee elects the judges in private sessions. They don't interview the candidates. They only have input from the so-called presidential councils, which are committees instituted at the federal courts, which consists usually of the president and the vice president and 5 elected judges. And those presidential councils interview the candidates and they thoroughly assess their qualifications. And they then issue a statement or an opinion on the qualifications. But of course, the election committee is not bound by that opinion. And we don't really know whether they really consider this opinion. And then maybe one final point is that the lack of transparency is not only that you can't apply for the job and you don't really know how many posts are open. At least usually that's not publicly advertised. You only get a press statement from the ministry saying that at this point, at that date, so and so many posts will be filled. But then the lists of the candidates are also not public. So the public or the press doesn't know who is on the list. They only know that at a certain date there will be the election, and then after the election there's a press statement issued by the ministry saying these people were elected. But of course you can't really know whether they're good or not because you don't know who was in the pool.
Okay. Just to add to this, So there are problems with the process, but do these problems reach a degree where the actually the integrity and the independence of the judiciary is compromised? Would you go as far as that?
That's of course a very good point, which I should have added, that I believe, while I do criticize this process, I believe that so far this has not really endangered the independence of the judiciary, because we have this mixture of the element of selection on the basis of merit and the political election. And we do have, I believe, in Germany, a very long tradition of the tradition and culture of the rule of law and the independence of the judiciary. So that in the end, if you look at the candidates who are nominated and the candidates who are then chosen, that overall, we can say that there are qualified judges at the federal courts. But of course, with regard to the topic of our interview, of our podcast, there is of course a danger once or if at some point in time in Germany the political majorities shift and then we might have the problem that one extremist party can basically push through all its candidates.
Right. Professor Donati, Italy is one of the countries which has a lot of experience of fighting between the judiciary and the government for decades now. You, as the president of the network of the councils of the judiciary in Europe, some countries have the more or less autonomous judicial councils, and some countries rely on parliamentary committees. What would you say are the pros and cons of these two models?
Okay, and I believe that each system has its advantages and its flaws. We have now heard about the Polish system, where a council for the judiciary exists, but it's a system with many flaws. And we have heard of the German system, which is based on the Minister of Justice model, where you have a selection of candidates made in a not transparent way. But at the end of the day, Christian Schmalz told us the legal culture in the country guarantees that you have judges independent and impartial. Of course, there's an old saying in the US, according to which you shoot an arrow into a far distant future when you appoint a judge. So it is not easy to find perfect systems. But I would say that in the system of parliamentary committees is based on the idea of democratic legitimization of judges, which is written quite clearly in the German constitution. The Grundgesetz states that each power comes from the people and therefore must be democratically legitimized. The risk of the parliamentary committees system is politicization. But we have to keep in mind that democratic legitimacy does not mean necessarily politicization. So representative institutions must play a role in the selection of judges by defining criteria and procedures for becoming a judge. But no interference by politics can be allowed, because a selection based on political reasons will end undermining the independence of judges and the appearance of independence of judges, which is important as well. The Judicial Council model, it has advantages clearly, because it helps to avoid politicization of judges' selections. But on the other hand, we have the Polish experience where the council is controlled by politicians. Council is appointed by the government party, basically, and therefore it does not guarantee the independence of judges selected. On the other way, also councils which are nominated by peers, by judges, may determine risks, because in that case, judges' associations who have a major role inside the council, could somehow influence the appointment of judges. So I would say that there is no magic formula on how judicial councils should be composed and on how recruitment of judges should be made.
Okay. How does this work in Italy? I mean, Italy is famous for its independent judiciary and its fearless poise towards taking on the government. But then again, the Italian system has been criticized a lot for a number of issues. How well does the Italian system work, and what can other countries learn from it in both directions?
Okay, in Italy, selection of judges is made through a competition. So you must be graduated in law, and there is a competition, open, impartial, and candidates are chosen based on their legal skills and knowledge of the law. Then you have a training period, and after that training, which lasts 1 year and a half, there is the formal appointment as a judge. So there cannot be any sort of influence in this phase by politics or by the Judicial Council. The Judicial Council instead decides on appointment to epical positions, president of courts, vice presidents, and so on. And critics in Italy are based on the fact that inside the Judicial Council, there are there are association of judges who may form a majority. So the idea is that sometimes or often candidates are chosen not entirely because of their merits, but also because of some sort of connection to a given judges association.
So it's a different sort of politicization.
It's, let's say, it's a sort of politicization which comes from inside the judiciary. So in this case, the judiciary can be seen as a self-referential body following its own logics, which of course protects very much from interference from government and legislator, but put our different kind of pressures upon judges.
Mm-hmm. Judge Hetnarowicz, this was exactly part of the PR campaign of the Polish government for the so-called judicial reform, portraying the judges as a caste, a secluded and detached and self-serving part of society, which has no ties to what was really going on outside, and basically a back-scratching community, if you will. Why did that convince so many in Poland?
Before I answer that, I would like to add something to our discussion, because in 2016 I attended the judges exchange in Germany, in Hamburg, and that moment, we had a great discussion about the process of nomination of judges in Germany and in Italy and in Poland. Just like now we have it, And that was the first time I had an occasion to hear about the process of nomination of judges in Germany and in Italy. And as you probably know, in 2016, we were in total different reality in Poland. And when I heard my German colleagues speaking, I thought, oh, the system is odd. And I really, those days, I thought that, the mechanism of nomination of judges in Germany is too closely linked to politics. And meanwhile, when I heard my colleagues from Italy, I had, oh, yeah, I feel safe. I mean, I understand the system, and I think it guarantees the independency, and there is a check and balance in the system. And of course, I was convinced that our system also guaranteed the independency of judiciary. Meanwhile, now we are in 2020, and the situation is totally different. When I hear my colleagues from Germany, I start to think, okay, maybe the system is not perfect, but still I can see that there is a process in which the independency is saved. Yeah. When I hear my colleagues from Italy, I think, yes, okay, you've got your problems, but still your citizens can feel safe about the independency of judiciary. And I would like to add that in our system, when you look at certain point of the nomination system, you may think, okay, maybe this one point is not perfect, but what is it? So what? It's only one point. It's only one element, and the meaning is that at the end, the judge nominated feels independent inside. The problem in Poland is that our changes of law are very sophisticated, and it's really a closed system, because it starts from the very beginning. Even the Polish School for Judiciary and Prosecution, the program in this school is totally dependent to the Ministry of Justice. They create the program of the school. They teach the future candidates for judges. They decide about what to teach them, how to teach them. Then you have this nomination process. You have the influence of the National Council for the Judiciary, which is politicized. Then you have the presidents of courts who are chosen by the Ministry of Justice with no impact from the judicial environment, from the judicial community. And then you have the indirect impact of the Ministry of Justice on the work of judges. And you also have the problems in the Supreme Court, in disciplinary proceedings against judges. And the whole system makes it's really closed. It guarantees that this independency of judge will be really limited. It is under control, and that is the biggest problem and the biggest threat in this system. And we cannot forget about it. And now I will answer your question: how it is possible that Polish citizens believed that judges are a kind of casta, and that we are so far away from society, just like on a glass mountain. We live on glass mountain. It also, the answer for this question also comes from my meeting with judges from Germany and from Italy in 2016. When I saw how judges in Germany work, when I saw my Italian colleagues at work, I saw judges who talk to people. There is a conversation between the client of the court and the judge. Judge is not afraid to discuss with people who come to court and who seek for justice. In Poland, judge has to stay silent, like a blank page. We cannot say anything. We cannot give any hints. We cannot give any opinions. The only way the Polish judge speaks is by the verdict. That's the only way we can speak to society. We judges even cannot explain the motives of the verdict in ordinary words. We cannot address our speech to the parties of to our clients, to the citizens, in more not legal language. Yeah, not using legal language, and that was always a problem of Polish society, of Polish judiciary. We were too far from society. When I saw judges in Germany in their work, and when I saw my colleagues, Italian colleagues, it was just brilliant. It was just like, wow, is it really possible to work like that? May I ask the witness not to stand up while during testimonies? May I? Is it possible? It occurred that it is possible, and it really does not take away the authority of my office when I am kind to people. And that was always a problem of Polish judicial community, and now we pay for that. Because you see, the Law and Justice Party, they just recognized the fears of Polish society when it comes to courts, and they just addressed it pretty precisely.
Right. Well, this judicial culture, which you described, is that a part of the heritage of the communist era?
Yes, exactly. I didn't want to say it because we also had the judges from Romania during this exchange, and they were in. Their position was pretty similar to Polish judges' position, and they couldn't do many things on during public hearings in courtrooms, and so did we. And we found out that was exactly the idea of judiciary from communism times.
I mean, this was another strand of the government PR campaign. The emphasis on the fact that the many judges used to serve under the communist regime, and now 30 years later, of course, it's obvious that few of these judges are still sitting on the bench. But now I kind of see how this argument even has any traction in the public. And nevertheless, it's true that the transition to democracy is always a particular challenge for the judiciary. Judge Schmalz, Germany was facing the same problem back then, and with the judges of the GDR. Is that still an issue in some respect in the judiciary?
I don't think so. At least to my knowledge of what I have experienced. Maybe I'm actually too young for that, which is a nice thing. But of course, I remember that after the unification, a lot of judges from the western part of Germany went to the east to sort of start rebuilding courts, and I believe that has been a problem in the years afterwards because there were too many people from the west sort of governing, or being the judiciary in the east, and that of course probably did raise some questions with regard to the acceptance of the judiciary by the people in the east. So I don't have but yeah, I think there were problems. But as far as I can tell, but I have never been, I've never been a judge in the East, so I'm probably not the right person to ask. I would say that today these problems do not exist anymore, but I'm not an expert on that question.
Maybe this is exactly the point, that there are so few judges with an Eastern German background in the German judiciary, right? I think it's in terms of percentages, is lower single digits. But generally, how important is it for the judiciary to be representative and to be a mirror of the population at large?
I think it's extremely important. I think the judiciary has to be as diverse as the population, and of course we are not. We already have problems with regard to the gender balance, which is very much okay in the lower courts, but as the higher you get, the less women are there. But of course, it doesn't stop with the gender issue. We have to get more people with different backgrounds, like from where they come from East Germany, also in the upper parts of the judiciary. And we need to have more people who have a migration background, or whatever you want to call that. And I think that is a big problem, that the norm judge, if you want to say, is white, heterosexual, and comes from a middle class background. And I'm actually a pretty good example for that, because my father was a judge, my grandfathers were judges, so I'm very much sort of like coming from a standard judiciary family. And we do need a lot more diversity, because the judgments will always be better if there are diverse people. And of course, if you have a diverse bench, a diverse bench will have, I think, a greater acceptance by the people seeking justice, and then you will have people being able to talk to those people in court, because they have they come from a similar background.
Right. Okay, to conclude, I would like to ask one question to each of you, and ask you to give an answer to that question. That question would be the dilemma that you hand over the judicial power over other people to someone needs to be legitimized in a democratic way, and yet this is the one way how to exert control over the judiciary. How do you solve this dilemma, and what would be the best practice? Maybe Professor Donati, if you want to start.
Yes, I believe there are two main kinds of legitimization. The one is technical, the other one is democratic legitimization. Technical legitimization is based on the idea that judicial appointment is a technical decision based on merits and capabilities of candidates, which requires an assessment on legal and personal skills of the candidates. And in this perspective, political representatives bodies are not well equipped to carry out this kind of assessment. So there is the idea that selection of judges should be left to expert panels. If we shift to democratic legitimization, that is based on the idea that the selection of a judge is of great importance for a political community. We see the US experience, but in Germany, Article 20 of the Grundgesetz, alle Staatsgewalt geht vom Volke aus. So the idea that you must somehow represent the people. And we as ENCJ always say that independence cannot be separated from accountability. Accountability and independence are intertwined. So otherwise, independence without accountability could lead to the Polish experience, where the judges were seen as a casta, and when politics took control over judges, the civil society did not move. And on the other hand, so we have to find a good balance and between those two different systems. Democratic legitimization aimed at obtaining accountability to society of judges, but also technical legitimization. So the idea that judges must be chosen based on their capabilities, even if they are chosen by politicians, but not on political grounds.
Excellent. Thank you very much. Judge Maltz, what would your answer be?
Well, I want to come from a different angle, perhaps. Of course, I very strongly believe in democratic legitimization of the selection of judges. And while I have criticized the German proceedings, I think they're okay. But I think we need, in the composition of the committee who selects the judges, I think we need a better balance and also some input or more input from the judiciary, but not too much, because I think the democratic legitimization should have priority. However, I think also with regard to judicial council, I think there's always danger, as we've seen in Poland, that politics will take over if you have a party which leads the parliament with a great majority. So I think to safeguard the judicial independence, we also need to work on much more public support for the judiciary. As I've heard my colleague from Poland saying that the Polish judges couldn't really talk to the people before in court. I think, of course, that is a big problem, and we can do that in Germany. But I think we still need to work on explaining our judgments and explaining what the judiciary really is about. And I think in that case, we need a continuing public debate on the role of the judiciary in a democratic society. And I think we also need the support of the press with this. And I think if you have a form of judicial selection which with democratic legitimization, but also you keep on talking about what the judiciary is there, and that it is there for the people, that is there to safeguard the rule of law. And if you're supported in that issue by a free press, I think that might help to avoid any authoritarian takeover, hopefully.
Thank you very much. Judge Hetnarowicz?
Okay, so I think there are two aspects which are quite important. One is to assure that the system of nominating judges and the system of judiciary is free, is legally free from the impact of legislative and executive powers. If there is a relationship of professional dependence between judiciary and the executive or legislative, then it may tempt to keep relying on the executive for the future of judges. And this may induce certain level of willingness to win over further appreciation of the political decision makers. And this way, it will undermine a lot the trust in judiciary in citizens, among citizens. So that is one aspect, and all European communities are obliged to take care of this legal side, legal aspect of process of nomination of judges. But the other aspect is this trust in courts among citizens in our societies. We all have to work for that. And in Poland, it is really hard to keep the trust in courts when you hear when the judiciary is so much attacked. When you hear that judges are communists, just look at me. I am 40 years old. And most of my colleagues are in my age. They are 40s, 50s. Yeah. They have nothing to do with communism regime. They have never worked as judges before 1989. But when you hear judges are communists, when you hear that judges are liars, that we don't follow the rules, that we don't care about people's needs, and that we are just doing things under our discretion, not following the law. You can hear it in Polish TV. Then it's really hard to find democratic legitimization for judiciary, because people just simply don't trust courts. And well, without this, judiciary needs silence. I mean, needs calmness. Yeah. If you attack judiciary so much by propaganda, then you will never get the democratic legitimization for judges.
Thank you so much. We haven't even touched upon the aspect of what Europe can do about all this, which of course is very much on everybody's mind right now, with a report on the rule of law due any minute, and basically one of the few hopes left, if at all, to restore the rule of law in Poland in the short run and in other places. So many issues could be touched upon, but our time is up. And I thank you so much for talking to me about these issues. Filippo Donati from Italy, Christiane Schmalz from Germany, Joanna Hetnarowicz from Poland. It was a pleasure and an honor to talk to you about these things. And I hope you enjoyed it as much as I do. And yes, thank you so much and have a nice day.